great, Diane.
Okay, great. Thank you.
Good afternoon, everybody. We had a few little gremlins that we had to deal with. First of all, I would like to acknowledge Melanie Davis from the University Center for Excellence in Developmental Disabilities. She'll be helping me in the background for this session. I'd like to acknowledge all the groups that were involved in the planning. It includes a League of Human Dignity, Independence Rising, Easter Seals, Nebraska, Madonna School and Community-Based Services, APSI, Nebraska VR, ADAPT Nebraska, Integrative Transition, Nebraska Family Support Network, the Nebraska Statewide Independent Living Council, Disability Rights Nebraska, the University Center for Excellence in Developmental Disabilities from Munroe-Meyer Institute, Nebraska Council on Developmental Disabilities, People First, the ARC in Nebraska, Harper Self-Directed Services, the Brain Injury Alliance of Nebraska, Assistive Technology Partnership, Outlook Enrichment, and PTI Nebraska. We do have a Dropbox, and Melanie will put that address in the chat. There is a list of the keystroke instructions for those who need it to make this more accessible. Depending on the device you're using, the toolbar could be either at the top or the bottom of the screen. There are 2 sign language interpreters that will be spotlighted. According to Zoom, if you have the latest version, you should be able to see them. I would like to thank Pamela and Couture, I can never say her name, for being involved in this series. All sessions are closed captioned. To turn it on, click on the little arrow beside the CC button on your toolbar, and then enable subtitles. If you have any questions for the presenters, please put them in the Q&A button, the question answer button, and Mark will ask the questions for you. Continue to use the chat feature just to say hello or to make comments you're thinking. Mark, I am now going to turn this over to you.
Thank you, Kathy. Sorry, I'm just responding to a few notes already. Good afternoon, everybody. My name is Mark Smith. I think a lot of you know me, but for those of you who don't, I'm first and foremost parent and sibling to adults with disabilities, intellectual and developmental disabilities. But my day job is that I work at the University Center for Excellence in Developmental Disabilities program at the Munroe-Meyer Institute. We're one of the federal partner programs in the state of Nebraska with the role of working to build capacity of systems and supports for people with disabilities in our state. Been here for quite a while and have had the really good fortune to work with many folks on the development of an Olmstead plan for the state of Nebraska, which sounds like a small deal, but it's actually a very big deal for our state. So it's really a privilege because I think it bodes well for what we'll be able to do in the future for our citizens with disabilities and their families. It's my great, I have the great pleasure of introducing our speaker for today, and I will be, as well as I'll be also moderating tomorrow. Today, but we'll be hearing from Diane DeLair, who works for another federal partner organization, the Protection and Advocacy Organization for Nebraska, Disability Rights Nebraska. That's probably enough saying Nebraska. But in any case, Diane, I can tell you, number one, is not only a valued colleague, but also has been very, very involved in Olmstead planning and in pursuing and advocating for an Olmstead plan for the state of Nebraska. And given that the Olmstead decision was a legal decision by the Supreme Court, it really made sense to have an attorney start us off, and Diane is an attorney. So without further, a couple of housekeeping items. Diane and I have talked a little bit, and she's broken up her presentation into 3 segments. And so one of our goals is to have a brief Q&A after each segment versus interrupting the presentation or saving them all to the end. If there's a really burning question that I think can really only be answered, Diane and I have talked about, I'll bring it to her attention. But ideally, we'll try and stay on track with just each segment and then doing a brief Q&A until we finish her presentation. I think that'll flow the best. But like I say, if you have something that's absolutely burning, please indicate in the Q&A, and I'll take a look and see about bringing that to her attention. And then I'll be bringing the questions to her attention at the end of each segment. We do have sign language interpreters. And we really appreciate them being here today. I think that just adds more to our the legitimacy of the fact that we're reaching out to the constituents and communities that we all work so hard to serve. But irrespective of that, at this point, I want to turn the microphone over to Diane. I think you're in for a treat. Diane is I think to say that this is in Diane's wheelhouse is not understating in any way, shape, or form. So Diane, if you will go from here.
Great, and thank you for that very nice introduction, Mark, and Kathy, and all the organizations and people who helped put together today's presentation and also tomorrow's panel. It's a real honor to be able to speak to you today about Olmstead, the Americans with Disabilities Act, and community integration in our state. As Mark mentioned, my name is Diane DeLair, and I am the Senior Staff Attorney at Disability Rights Nebraska, and we're the protection and advocacy system for Nebraska. I've worked as an attorney for disability rights for over 20 years now, and so I've been around to see a lot of changes and advancements, and also things that aren't changing as quickly as we'd like to see. One of the most important functions of our organization at Disability Rights Nebraska is our mandate to investigate abuse and neglect and to respond to that. We also monitor the places where people with disabilities live, work, and receive services all across the state. And that's really a privilege to be able to travel the state and talk to folks who may otherwise not have a voice. Often we go to places and talk to people who are hidden away, isolated, segregated, and congregated. Today, we are talking about the Americans with Disabilities Act and the U.S. Supreme Court decision Olmstead versus LC. This is one of the most important civil rights cases in our history. And I have the pleasure to talk to you about that today. So what do we know? What we know, and the law affirms, is that separate can never be equal, regardless of whether the segregation is based on race, disability, or some other type of identity. Now keep that in mind. Olmstead versus LC is often referred to as the Brown versus Board of Education case for individuals with disabilities. So keep that in mind, that what we know is that separate is not equal. As Mark mentioned, I've divided the presentation today into 3 separate sections. First, I'd like to discuss the Olmstead decision itself and how the U.S. Supreme Court interpreted the Americans with Disabilities Act. And it's important that we spend a little bit of time on this foundation, because I think it does deserve the time to walk through the process and kind of go back to basics with the ADA. And my hope with this is that it'll help sharpen our focus and understanding of the language being used. So oftentimes when we're talking about Olmstead plans, what is that? What is an Olmstead plan? Integration mandate, the most integrated setting. And so my hope today is that we can kind of go back to the ADA, go back to the origins of some of this language, and to better understand how it relates to the Olmstead decision. Second, I'd like to go through, kind of walk through a little bit of the litigation, the settlement agreements that have occurred following the decision in Olmstead. What we know is that Olmstead, as we'll talk about later, involved in one institution, but since that time, courts quickly have made clear that Olmstead it applies to all state and Medicaid funded institutions, including nursing facilities and privately owned facilities as well. Courts, also found that Olmstead applied to individuals living in the community who are at risk of institutionalization or placements in isolated, congregated, and segregated settings. And that's an important feature that we'll talk a little bit more about today. Lastly, I'll briefly talk about Olmstead efforts in Nebraska, the involvement that our organization has in prompting the state to move into the direction of developing an old Olmstead plan, and some observations on things that we've seen across the state. So a lot of you may recognize this picture. This is President George H.W. Bush signing the Americans with Disabilities Act. And this was passed by a bipartisan Congress in 1990. And I wanted to mention a few things that Congress had stated during the passage of the Americans with Disabilities Act, and also some remarks that President Bush declared at the signing ceremony, because they're very powerful, and it all relates to what we're talking about today. Congress made a number of historical findings, and this included recognition of our history of institutionalization in the United States. Congress stated, historically, society has tended to isolate and segregate individuals with disabilities. And despite some improvements, such forms of discrimination against individuals with disabilities continue to be a serious and pervasive social problem. Less known is what President Bush stated in the signing ceremony. President Bush declared that the ADA takes a sledgehammer to a wall which has for too many generations separated Americans with disabilities from the freedom they could glimpse but not grasp. And the last comment President Bush made before signing the ADA was let the shameful wall of exclusion finally come tumbling down. Those are really powerful words, and integration and deinstitutionalization and people actually being a part of their community. That's what this is all about. So just to take a step back to the basics, I think it's always a good idea to do that. The Americans with Disabilities Act, you may not know, is actually organized under 5 titles. And most commonly, though, we talk about the first 3. So we know that in Title I, we're looking at employment, and Title I states that this prohibits employers from discriminating against qualified individuals with disabilities in applying for jobs, hiring, firing, job training. Now, Title II, that's what we'll be focusing on today, states that Title II protects qualified individuals with disabilities from discrimination on the basis of disability in services, programs, and activities provided by state and local governments. And we'll dive into that in a little bit more detail. That is Title II. Title III is states no person who owns, leases, or operates a place of public accommodation may discriminate against an individual on the basis of disability in the full equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation. And Title IV, which you may know or may not, involves telecommunications. And Title IV requires that telephone companies provide telecommunication relay services that allow individuals with hearing or speech impairments to communicate using a TTY or other non-voice device. So that was captured in Title IV. Title V is a catch-all. It's a miscellaneous, has several different miscellaneous sections, and they apply to all 3, or excuse me, all 4 of the ADA titles. So we're talking about Title II of the ADA, and this is programs, services, and benefits. And I've put up the statute here. This is the federal law, which states no qualified individual with a disability shall by reason of such disability be excluded from participation in or be denied the benefits of services, programs, or activities of a public entity, or be subjected to discrimination by any such entity. So when we look at the ADA and enforcement, we know that Congress passed the ADA, signed by the President, and the Department of Justice, they promulgate the Title II regulations that allows for enforcement of the ADA. And then we have the courts who interpret the law and the regulations. And so the DOJ, the Department of Justice, the Attorney General has the responsibility for publishing those regulations and implementing the requirements of Title II, which are those state and local government services. So now we get into the details, sort of the teeth of this title. And Title II, the regulations, part of the regulations state that it requires public entities to administer services, programs, and activities in the most integrated setting appropriate to the needs of qualified individuals with disabilities. And that's where we get that language that we'll see time and time again, that it is a form of discrimination to unnecessarily only provide services in a institutional type setting. Now, what does integrated setting mean? And it is further defined that the integration regulation explains that the most integrated setting is one that enables individuals with disabilities to interact with non-disabled peers to the fullest extent possible. So we have these regulations in place. We have the ADA passed in 1990. And we have the regulations that have been enacted to enforce the ADA. So I want to go ahead and move to Olmstead versus LC. And up on the screen, you can see a picture of two of the plaintiffs in the Olmstead case. And I should say that as this case worked its way up to the U.S. Supreme Court, unfortunately, the name refers to Tommy Olmstead, who was the HHS commissioner for the state of Georgia, and LC is Lois Curtis. So the story of this case begins with two women, Lois Curtis and Elaine Wilson, and they both have a diagnosis of mental illness along with developmental disabilities, and they were voluntarily admitted to the psychiatric unit in the state-run Georgia Regional Hospital. And they had spent some time there receiving treatment and mental health care and also rehabilitation. And at one point, the mental health professional stated that each of them was ready to move to a community-based program. However, there were no programs for Lois and Elaine to be discharged to. And the Legal Aid Society of Georgia took on this case to represent Lois and Elaine in their quest to move back into the community, out of the institution. And unfortunately, the women remained confined in the institution several years after their treatment had been completed. So that is the basis for the lawsuit that they filed, alleging that due to their disability, they were being discriminated against under the Americans with Disabilities Act. So it took some time for this case to weave its way up to the appeals court, and it made its way to the U.S. Supreme Court. And that in and of itself is pretty amazing. So in 1999, Justice Ruth Bader Ginsburg gave the decision of the court. And she first explained, the court explained in her decision, in the decision of the court, that the decision that they were to hold reflects two evident judgments. First, institutional placements of persons who can handle and benefit from community settings. It perpetuates unwanted assumptions that persons so isolated are incapable of or unworthy of participating in community life. Second, confinement in an institution severely diminishes the everyday life activities of individuals, including family relations, social contacts, work options, economic independence, educational advancement, and cultural enrichment. That's pretty powerful language coming from the court as it interprets the ADA. So the court further stated, the court further stated in Olmstead versus LC that unjustified segregation of persons with disabilities constitutes discrimination and violation of Title II of the ADA. The court announced that public entities, state and local governments, must provide community-based services to persons with disabilities when 1, such services are appropriate, 2, the affected persons do not oppose community-based treatment, and 3, community-based services can be reasonably accommodated, taking into account the resources available to the public entity. So what this really boils down to is this: unjustified segregation, or in other words, requiring people to receive services in a setting that is isolated or separated from the community, was discrimination against persons with disabilities. And I did put a link here at the bottom of the page to our Olmsted page at Disability Rights Nebraska. We have a lot of different materials on Olmsted, and also on the work of Olmsted here in Nebraska. And I'm so sorry about the dog barking here. Okay. Okay. As I mentioned earlier, the another big point the court stated was that the ADA and the Olmsted decision extend to persons at serious risk of institutionalization or segregation. And it's not limited to individuals currently in an institution or other segregated settings. And this is a really powerful language from the court. Individuals need not wait until the harm of institutionalization or segregation occurs or is imminent. So, you know, in order for these protections to apply, you can be at risk. So if services are cut and, you know, or you're not able to receive the types of services that you need, and you end up going back into an institutional type setting, you know, the law would apply in that context. Okay, now we get to the point where we're talking about what in the world is an Olmsted plan and what the court have to say about that. So the court held that you know, this was a big, go back to this screen. So the court is saying to states, look, if you're going to provide services to people with disabilities, you have to do it in a community-based setting if that individual would prefer that, and you can't rely on institutional type settings as we move forward. Of course, they said that a little bit more elegantly. So the court said, look, states, you're going to need to start planning for community integration, and you can no longer rely on not only institutional physical settings, you know, your regional centers, you know, your other types of ICF IEDDs. You need to start making a plan to demonstrate that you're working towards this goal to allow and to provide the capacity for people to receive those same types of services in the community. And the court, they understood that this couldn't happen overnight. So they said one of the defenses state you can use or rely on is the creation of an Olmsted plan. In other words, if you're sued for violation of the ADA's integration mandate, you can show the court, hey, look, we have a plan. You know, we understand you know, this is a huge change. We have a timeline of 6 to 8 years of here's what we plan to do so that we are meeting our federal legal obligations under the ADA and Olmsted. So the court said, okay, states, you can rely on this as a defense. And but wait a second, these plans have to have concrete goals, timelines, benchmarks for providing and implementing community-based services. It cannot contain vague assurances by the state. We're going to increase community-based planning, or we're going to increase the availability of services in a particular area. And we'll talk more about this later in the presentation, but also you'll be talking a lot tomorrow about Nebraska's Olmstead plan in a lot more detail. And these are the things that I'd like you to think about as the presentation happens tomorrow about our own plan that was set forth. So as I mentioned, what is an Olmstead plan? It describes how the services will be provided in the least restrictive and most integrated setting. So let's say that you're in need of mental health treatment. And the only option should not be an institutional setting. It shouldn't be, it's the regional center and that's it. An Olmstead plan is a systems change document, and this will take time. It should have short and long-term goals as well. We'll talk a little bit more about what must be included in a plan, but I just wanted to give you the basic structure of the decision and also how it relates to the ADA. And I'll stop there. That's part one of the presentation to see if there are any questions.
I'll unmute. I don't have any questions at this time. Do folks want to pose any questions? Please type it into the Q&A, and I'll bring those forward to Diane.
Okay, so yeah, if you do have questions, go ahead and put them in the Q&A box, and we'll try to get those answered.
I do have a question for you, Diane. Does the plan specifically have to be submitted to anyone, an agency, for example?
No, it's not about whether or not the plan is submitted somewhere. It really needs to be something that the state, they have the ultimate responsibility for not only developing but implementing the plan. It rests solely with them. However, as we talk in more detail about what needs to be included in a plan in order for the state to use it as a defense in an Olmstead lawsuit, we'll get into a little bit of the nitty gritty, but it's really the substance of the plan, and also there has to be funding included in this to make these changes. And there also needs to be, the state needs to take a look at the processes. It's not always about just adding more dollars in. It's also looking at the way funding is administered so that you can do things in a more efficient, it doesn't have to cost more. Let me just go ahead and move on.
Well, there were a couple of brief questions.
Sure.
Is this Nebraska's first plan?
Yes, it is, and I'll touch on that shortly. But the plan that was issued by the state in 2019 is the first plan. And so I should mention that it's a living document, so it can change, it can respond to things that are happening, and it should. So it's not a static type of document.
Mm-hmm. And one last, isn't Nebraska one of the last states of all the states to have drafted a plan?
You know what it is, and we'll talk a little bit more about that. And it's important, you know, that we have a plan, but also the implementation of what it is we're doing. That has to be, you know, there has to be some action behind this. You cannot just have the document. And there's been litigation that has addressed, you know, hey, the state has this plan, but there's nothing concrete in it. It's just some aspirations about we want to get more people living in the community.
And finally, so the last question is, so this is a plan for the state, not how the state serves a particular individual.
Well, yeah. So the Olmstead can be the decision started with you know, 2 women in an institution. However, Olmstead planning, the actual document talks about the different systems. So a lot of the cases have emerged out of you know, health and human services. So for example, you have 5,000 people on your waiting list, and for, let's say, for example, for developmental disability services. And your Olmstead plan says that we're going to move 200 people a year off that waiting list. Well, I think courts, well, they have found and would find that, you know, that's great about getting people off the waiting list, but it does not move at a reasonable pace. And so you're going to have to step up your efforts to reduce that waiting list. If that helps illustrate that particular point.
That's all I have, Diane. Thanks.
Okay. All right. So Olmsted Enforcement. We, in 2009, under the President Obama's administration, he created a special section in the U.S. Department of Justice solely dedicated to Olmsted enforcement. And this was a big priority for the administration and for the Department of Justice, the Civil Rights Division. So I have a link on here to give you an example of some of the issues and cases that okay, so this is the ADA.gov page. And so if you, you know, want to read in a lot more detail about the enforcement efforts of the DOJ, this is a good page. But if we take a look at this, Olmsted has moved way past physical types of institutions, because what we know is that people can live in the quote unquote community and their life can still have an institutional regimented you know, type of existence. So it's not the 4 walls. That can occur in the community as well. And here are all of the cases by issue so far that the DOJ has been involved in, and these are suits that they've brought on behalf of the U.S. government, and also other disability advocates across the U.S. So you can see that lots of cases involving integration with nursing homes. And there's a lot of case law out there on these different areas. So I'll just kind of scroll down so you can see this, but there's been a lot of precedent and case law in different areas of services, including education, where the integration mandate has been enforced. So I wanted to briefly talk about a few, and I believe the PowerPoint is in the Dropbox, so these links should be available to you. And I also will have an Olmsted resource list of different materials that you might want to consult if you have further questions. And that'll be in the Dropbox shortly. All right, let's go back. Sorry. Okay. All right. There we go. Sorry. All right. So here are some states that experienced litigation, either suits filed on behalf of the United States or along with other disability organizations, other protection and advocacy organizations. And I'll just briefly talk a little bit about some of these interesting ones, and you can find these also on the Olmsted resource list. So Illinois, for example, after the Olmsted decision was handed down by the U.S. Supreme Court, Illinois was ranked 50th in the U.S. with respect to its utilization of institutions, its reliance on institutions for people with disabilities. And they had this Herculean effort that was underway, and they developed 3 separate class action lawsuits challenging this heavy reliance on institutions. And all 3 of those lawsuits in the mid-2000s resulted in settlement agreements, and with major changes in Illinois with respect to how services are delivered to people with physical disabilities, developmental disabilities, intellectual disabilities, and other physical disabilities. So these were folks who were forced to live in nursing homes because services weren't available, or in large institutions for people with developmental disabilities. And as a result of those 3 agreements, settlement agreements, over 22,000 people were moved from institutions into the community. In Oregon, the Olmsted decision and integration mandate was extended to workshops. So the state was sued by organizations, and the U.S. Department of Justice intervened as well. And what was found through the evidence and what was happening in their state is that the provision of employment services through workshops, there was such a heavy reliance on that, and not through supported employment or other methods. That was a violation of the ADA in Olmsted. It says if you are going to rely and spend money on these workshops, you really need to start moving away from that and offering choice for people. And so, major changes occurred there with respect to how people received services in the employment context. And that was a really interesting case with respect to the extension to these day service type programs. So if we, take a look back, the initial Olmsted decision was 2 people trying to receive services and live in the community. And here, this is states you cannot rely on sheltered workshops for day services or employment type of services, because that's just another avenue of exclusion, isolation, and segregation for people. And oftentimes sheltered workshops are places that pay subminimum wage. And so there's a real movement away from that. Lots of cases involving at risk of institutionalization as well. And that's key. So you don't have to find yourself in an institution for Olmsted and those protections to kick in. So in Delaware, North Carolina, and New York, those are 3 states that were involved in litigation involving people with mental illness. And I mention these because we are moving away from state-run institutions to privately run facilities. So the way this works is that, okay, the states know that privately run facilities are sort of the means of where people are living and maybe receiving services, mental health services. And these are large congregate settings or smaller type of homes. But what they all have in common in each of these states is that, well, they're, in the community, they're very institutional. It's very regulated. There's a lack of privacy. You have to, check yourself out if you want to, actually, leave and go do something outside of the facility. You may not have privacy. Meals are at a certain time. So while this isn't a state-run institution, it's funded oftentimes through Medicaid. It's licensed by the state, and the courts in each of these cases or settlement agreements, what they found is that by relying on these privately run facilities is a violation of the integration mandate. So let's look at Delaware. The agreement there, based on Olmsted and the ADA, just an overview of what that settlement agreement looked like. It provided for relief for more than 3,000 individuals unnecessarily institutionalized, not only in the state-operated psychiatric hospital, but also in state-funded private psychiatric facilities, and also people at risk of needless institutionalization because of a lack of community supports. So the focus on this was that, okay, we're going to really look at what types of services are needed and how many people are we talking about. So you'll see in this agreement, it's not, you're going to try to do better in getting people to be able to live in the community. It's it's 3,000 people. And you're going to, over a period of time, construct a plan to meet that demand. And if you'd like to read more about it, it's very interesting to look at some of the key points of these settlement agreements. Just again, in Delaware, they're able to break down how many people are we talking about and what's going to be needed? What will the state need to develop or shift over to provide this type of service? So in Delaware, we had integrated supported housing, vouchers or subsidies for 650 people. All of these numbers are based on what the demand was or what the need was. And so on the outset, they determined that 3,000 people were unnecessarily segregated. Other community supports in the behavioral health context. All new housing is supported housing with no more than 20% of people with disabilities per building. Supported employment, 1,100 people are in need of that. Rehabilitation services, family and peer supports, discharge planning process, including community providers, statewide quality management system. And, they also agreed that the state, they're going to leverage additional federal dollars, significantly expanding the total available funds for mental health services. And, the agreement, the center of this agreement is that the mental health system will shift from relying on state-funded institutional care to ones focused on Medicaid reimbursable community-based services. It looks like I need to move it along here, and it looks like we might have some questions here.
Would be good if I unmuted myself. Yes, we do. A couple of questions, Diane. One is, I understand Nebraska DHHS has been heavily involved in planning, but other state level partners did not engage in the first planning efforts. What efforts have been made to engage other partners, that is, agencies with housing and economic development missions, to be involved on an ongoing and meaningful level?
So I'll try to answer that question. There are efforts being made by the state and the state agencies to try to corral the necessary people to be involved. And I know that behavioral health has made some strides in the area of a work group for housing. I think that this question might be maybe more appropriate for maybe Tony Green tomorrow on the panel. Try to see from their vantage point what types of things they've been trying to do to get people to the table. Because ultimately, it's leadership, it's the top down, and if this is something that the state plans to take seriously, people need to get to the table.
Thank you. A second question, there seems to be a population of individuals at high risk for incarceration, jail, or psychiatric hospitalization that don't necessarily meet the criteria for example, the DD waiver or benefit from community mental health services. Are the needs of this population included in Olmsted planning?
Well, they should be, and I think that bridge is difficult. If you're taking a look at the plan tomorrow in a little bit more detail, I think there are efforts underway to help bridge that gap, but this is something that's been around for as long as I've been working in this area, is that there are the silos, and that's always a constant problem. You might be receiving waiver services, but guess what? That doesn't mean you can't receive treatment for mental health, and how do these two divisions work together? So that's a huge issue. Is it being addressed enough in our efforts? In my opinion, no.
Okay. There's a question, I think, specific to your comment about mental health and housing. Are there non-government, that is, or people with disabilities on this housing subcommittee that you're aware of?
I'm not aware of the membership of this work group or committee, and did ask for them to release the minutes or the agendas of these meetings. But this really brings us into our next section about observations in Nebraska. And I would
just add, and this might be another question that could be better answered by Director Green tomorrow. So
yeah, absolutely. So a lot of the work that we have done and continue to do at Disability Rights Nebraska, as I mentioned, is going out into the community and talking to people. You know, are there issues that we can provide assistance with on an individual basis? But what we also see are patterns of things that are happening. And all over the state, what we began to really notice on a more disturbing scale were the conditions in assisted living facilities all across the state. And these are not grandma and grandpa's assisted living facilities. These are, they're licensed the same, but the 90 to 100% of people living there have a severe mental illness. And there are these types of facilities all across the state, and we've seen them. We've talked to people who live there, and they are isolated, congregated, and segregated. Now, in 2014, the Division of Behavioral Health contacted the Technical Assistance Collaborative to consult with and provide some work looking at integration in the area of behavioral health. And they issued this report. Oh no. Okay, well, I'll get that up there, but a report was issued in 2014 looking at the conditions in Nebraska, looking at, you know, where are people living, where are people receiving services, what is the climate for folks in the state. Let me see if I can bring this up here. Oh, here we go. I couldn't find this document on the HHS website, but okay, hold on. Sorry about that. Okay, well, that's not working. So this plan was released in 2014. Oh, not a plan, but a report. And essentially it said, look, we've done a scan of the behavioral health system. Here are some short-term and long-term recommendations about how to get started into moving towards a more integrated service delivery system. Here are some things that we would recommend based on our experience. And in this report, the consultants said, oh, by the way, you really need to, we recommend that you really move forward with developing an Olmsted plan. Because at this point in time, you are subject to litigation. You don't have one. And so the Technical Assistance Collaborative, they came back in 2016 and developed a strategic housing plan. Okay. Okay. Can you see that? Nebraska Supportive Housing Plan. And this was in 2016. And this was a set of recommendations, methodology about looking at community integration in the area of behavioral health, and supported housing was recommended moving into that direction, that we take a leadership role in moving into that direction. And so we have here a 100-page report that HHS received about how to move forward on a supportive housing plan for people who have a serious mental illness. Now, the reason I show this to you is that there's a lot of really good information in this about the different programs in our state. This was, really in-depth look at what's going on in Nebraska. So tomorrow, when you're talking about the Nebraska plan that was submitted, what we are extremely disappointed about is that a lot of these recommendations, short-term and long-term goals, didn't make it into the plan. These reports aren't even referenced in the Olmsted plan, which to me doesn't make any sense, since they speak directly to community integration and recommendations on how do we get there. Oops. So going back to Olmsted plans. So looking at the plan, if you take anything away from today's presentation, it's that you've got to determine what the need is in the state in these different areas. How many people are on the waiting list for developmental disability services? How many people are hospitalized, homeless, incarcerated, live in institutional settings in the so-called community? How many people are in assisted living facilities not receiving the services they need and are committed repeatedly to the hospital, back to the regional center, homeless, back to another assisted living facility? What are the numbers? Because you can't plan. You can have aspirations of, we really want people to have the opportunity and the choice to live in the community. But how can you possibly plan if you don't know what the numbers are? So if you look at the plan that has been submitted or developed by the state, let's look at the area of the developmental disability waiting list. Where are the numbers? How can we appropriately plan to move people off the waiting list if the actual numbers are not in the plan? What about all of these questions here with respect to the need for services in the community for people with serious mental illness? The plan relies on a lot of different great projects and programs, but I want you to look at the numbers. Where are they? What are we doing well in this state, and what needs improvement, and how many people are affected? Because that's what the courts will be looking at. So I know that I am pushing up on the end of my time, and I just want to thank you for the opportunity to be here and talk about these really important issues. I'll stop right now to see if there are any additional questions.
None at this point.
Okay, just a little brief, we'll go through this quickly. So in our monitoring work at Disability Rights Nebraska, we were just so concerned and still are concerned about the lack of services for people in the community. And we thought that one way to get this moving would be to get some legislative involvement. And we, along with other stakeholders, other groups, you're probably on this phone call, worked with Senator Kathy Campbell and the Health and Human Services Committee to pass LB 1033. And that was the law that required HHS to let's create and implement an Olmstead plan after many years since the Olmstead decision. The Olmstead legislation that was passed created a Olmstead Stakeholder Advisory Committee, and in the legislation, the committee was to advise if a consultant is needed to help the department develop and implement the plan. So, Senator Walz, also very involved and passionate about people with disabilities. The ADA introduces Bill LB 800, so that would assist in allocation of funding for the state to hire a consultant. Unfortunately, that bill did fail, and the Planning Council on Developmental Disabilities announced it provided funding to HHS to retain the consultants from the Technical Assistance Collaborative for the development of an Olmstead plan. And so the consultants from TAC began their work here in Nebraska with an on-site visit in August of 2018. And they did a tremendous amount of work contacting stakeholders across the state, doing a scan of what's happening here with respect to community integration. And here's a document that breaks down the timeline in a lot more detail with respect to the timelines and the work that the consultant TAC did with the state of Nebraska, drafting strategies and guidelines, making its way into the plan that was submitted December of 2019. So if you're interested, you can take a closer look. TAC has been hired to continue its work with Health and Human Services to monitor the plan and to assist in its implementation. And as I mentioned, there'll be a lot more detail on this tomorrow. And here is a link. Oops. And so here's a link to what was submitted with respect to Olmstead efforts with goals. It's a lengthy document, and the link is there if you'd like to look at it further. I know this was a lot of information. I hope it was helpful, or at least a good start with respect to a conversation about Olmstead in Nebraska. The original Olmstead decision, as I mentioned, has extended far beyond simply the institutional physical setting, but also into other programs and services that the state delivers. I know that in a time of COVID, you know, the planning has and implementation for this has stalled, and that's understandable. But at the same time, the federal law remains in place, the precedent that's been set, and what we rely on to move things forward. People are relying on these changes to be made. And so we still have a lot of work to do. And I look forward to discussing this, you know, continuing the conversation. Mark, are there any more questions?
I have to unmute to actually talk and have you. There is a question as to housing. What other state divisions, agencies are needed to actually develop a plan?
So that's a great question. And I'll just go back up to so we have a document that was released in 2016, the Nebraska Supportive Housing Plan. And here you have in great detail a roadmap, if you will, of short-term and long-term goals of how to achieve this, about the necessary organizations, different federal grants and monies that our state could be applying for. So, you know, we've received this very lengthy report with recommendations, and you know, the roadmap is here for behavioral health, and it's been here, you know, 2014, 2016, and we believe that the current plan that's been submitted and the final submission doesn't accurately, or it doesn't capture the scope of the work that's been done previously and the recommendations that have been made by the experts in this area.
Right. Yeah, I think clearly we're on a path, but we have further to go on the path, is what I hear you saying, Diane. Another question is, have we ever had legal action based on Olmsted in Nebraska that you're aware of?
Well, we have, actually. If you'll bear with me for just a moment. So if you recall, several years ago, not too far away, we had Department of Justice involvement at the Beatrice State Developmental Center. And that was a two-prong approach by the Department of Justice, or two types of investigations that were occurring. And I'm at the website for the Department of Justice, and here is U.S. versus Nebraska. And so the division, the Civil Rights Division, we're looking at two separate things. So there is a separate statute. This is a horrible acronym, CRIPA, but it's the Civil Rights for Institutionalized Persons Act. And this gives the authority to the DOJ to come in and conduct an investigation into abuse and neglect and failure to provide treatment. But they also looked at the lack of capacity in the community, specifically in the developmental disability community, about folks who wanted to live outside of the Beatrice State Developmental Center. So if you'd like to read more about that, or you might have also been involved in this, lots of information here. The state here has agreed or funded creation of new community programs. So they're talking about the census that's been decreased, but the result of the work of the DOJ was a very strong ADA Olmstead focus. So part of that agreement that DOJ made with the state of Nebraska is that you need to increase your community-based services in this particular area.
All right, battling here. Have there been any other suits related to transportation or employment that you're aware of?
In Nebraska, no. With respect to employment in other contexts, I mentioned the Oregon case, transportation, that is a component that needs to be addressed in an Olmstead plan. And I'm not aware of any specific suits involving Olmstead and transportation.
Oh, well, and an amendment, the requester talked about, well, are there goals in the plan?
Oh, in Nebraska's plan.
Yeah.
Yeah, there are. That is addressed. It's our opinion that they're not adequate with respect to determining the scope of the need. So, for example, in Nebraska's plan, it's we will increase ridership, X number of times or people. Well, that really doesn't go to the heart of what people need. People need transportation to get to and from work, medical appointments, other things. And so sometimes it's not increasing ridership, but it's increasing the time of day that you're able to access the transportation. And so we'd like to see things moving into that direction instead of numbers that maybe don't really correlate with the actual need.
Okay. That's all I have for questions, unless anybody has anything else.
Well, again, I would love to continue this conversation. Also, if you want to talk about this further, my contact information is listed on the screen. It's been a great honor to present on this material today, and I'm looking forward to the panel discussion that will be conducted tomorrow.
Thank you, Diane. That just you delivered as promised. There are a number of folks that have mentioned in the chats as well as the Q&A about the presentation for tomorrow and getting registered, and that information is in the chat in terms of the links to get registered. And we hope that, I think we have an excellent panel coming in, which will take us even further into I don't want to say the weeds, into detail on Nebraska's efforts around Olmstead, which, again, as I mentioned in my earlier remarks, I see as one of the most critical activities going on in the state right now as relates to improving improving services and supports for persons with disabilities. And it has teeth. So I think that's quite critical. I want to remind you as well, so that information to register for that is in the chat, but also Melanie Davis and I have both listed our emails. If you're having problems either getting to the registration, or if you're having problems getting to the Dropbox folder that has Diane's materials as well as the materials the presenters will be using tomorrow, you can let us know and we can help out, because we want to make sure this information gets out to as many folks as possible. It's again very critical from my perspective to what disability services will look like in Nebraska going forward. So are we good, Kathy? Do you want to take us home? Or
Thank you, Diane, for such a great presentation.
great presentation.
Thank you. You're welcome. It's a
And
pleasure.